Please note that this episode contains references to sensitive subject matter. Welcome to Law Syrup, the show where we talk with special guests about hot topics in Canadian law. This podcast is a co-production with the Ontario Justice Education Network, also known as OGEN. I'm your host, Herman Wong. Let's tap in. Before we begin, please know that this show is not intended to be legal advice or a replacement for a legal representative. Hi everyone, Happy New Year and welcome to Law Syrup. Today, you'll hear my discussion with Meaghan Cunningham. Meaghan is not only a Crown prosecutor, but she is also the current chair of the Ministry of the Attorney General's Sexual Violence Advisory Group, and she is a highly requested speaker. Recently, Meaghan was one of the prosecutors on the Hockey Canada trial that has been much covered in Canadian and international news. Together, we talk about her beginnings as a Crown attorney, how she balances work life and the emotional aspects of her cases with her life at home, and misconceptions the public may have about criminal court, the Hockey Canada case, and the role of Crown attorneys. Now, as a disclaimer, Meaghan did not speak to me today as a representative of the Ministry of the Attorney General, but rather sharing her own personal thoughts and reflections. So nothing she says here should be taken as the words of the ministry itself. With that being said, here's our discussion. All right, so Meaghan, thank you so much for joining us today. How are you?
I'm doing very well, thanks. Thanks for having me.
Yes, it's so exciting to speak to you. How are you enjoying the weather outside?
It's a lot warmer today than it has been in the past, so I'll take it.
You know what? Like yesterday, there was freezing rain, wasn't very happy. Right now, we're in that moment where it's after Christmas, and typically I enjoy snow for Christmas because it, fits the season. But now everything is just turning to slush, but hey, the days are getting longer, so that's great.
Yeah, I don't quite feel that yet, but I know it is objectively true.
Yeah, so just waiting for the daylight to come back, and I can stop taking my vitamin D supplements.
That would
But
be nice.
yes, but let's just jump right into our discussion. Thank you so much for joining us. We're so looking forward to hearing from you about your own career and also about the cases that you've handled, particularly the Hockey Canada case that's been on the top of many people's minds. So let's start at the very beginning. Why the law? And I know you went to U Ottawa to do the common law program. Do you remember when you first started thinking about a career in law?
Well, not exactly, to be honest. I mean, I would say that I was always interested in justice issues, but not necessarily the law or legal issues. In high school and, undergrad, I was particularly interested in social justice. But at that time, I really thought I wanted to be a doctor. That really was where I was sort of headed. And I was in the art sci program at McMaster for undergrad. And I did my undergraduate thesis on media representations of conjoined twin separations.
Really?
Yeah. And what really fascinated me about that area was just how intertwined these sort of medical, social, cultural, sort of gender decisions were in that particular case. And I think where I ultimately kind of landed on this was this overarching question about like, why were some of these decisions that were made medical decisions? Like who decided that doctors, get to make some of these decisions? And so, when I finished my undergrad, I did really think that I was interested in sort of medical ethics. And I thought I still might go to medical school. But I also thought that law school might be a good place to sort of explore some of these ethics and policy questions that I had. So when I went to law school, it wasn't really necessarily with a career in law in mind. But that was sort of my path to getting to law school.
That's super interesting because originally when I was in elementary school, I always thought I would be a doctor, as most children do. And actually in careers class, we had this website where you do a quiz to see what
Mhm.
career suits you best. It was like a called career cruising or something like that. And I did the quiz, and the number one choice for me was bioethicist.
Okay,
Like very
interesting.
niche and kind of related to what you were thinking about. And I was like, oh, that's interesting. And I think the second one was actually judge. And I was like, oh, they're very interesting results. But eventually I went to high school. Well, during high school, I realized that science was not my thing. But I was like, hey, I like social justice. I like to read and write. So, law sounds pretty good.
Yeah, I mean, there's a lot more overlap than people might think, really, between
Yeah.
law and medicine and science. So.
Yeah. So when you went to law school, did you know you wanted to do criminal law in particular?
No, not at all. So I started law school not, thinking about criminal law at all, thinking more about medical ethics and sort of policy. I didn't plan on, being a litigator, at all necessarily. And then what happened was I sort of fell in love with criminal law, in first year. It was sort of my first year crim law class. It was just kind of, I felt like my eyes were just sort of opened. And the issues are so interesting. They make television shows and movies about, criminal law and trials and things like that because they're interesting, right? And because they matter, like these cases, have that intersection of being fascinating, being important, mattering for everyone involved, right? The stakes are so high for victims of crime, for those accused of crime. And so, criminal law quickly became sort of my primary area of interest, once I started law school. But even once I sort of discovered that criminal law was what most interested me, I wouldn't say I was necessarily leaning towards being a crown, right away. And, I think my experience in law school, is that there was very much this sense that the criminal justice system pits the vulnerable average person against the sort of soulless machine of the state. And there was this sense that the sort of the honorable work is defending accused persons against the state, not being sort of a cog in that soulless machine of the state. And so that was sort of where, my sort of head was at, in law school.
Hmm.
And I think there's no question that, being a defense lawyer is honorable work. And defense lawyers play a critical role, in the criminal justice system. But when it came time to sort of apply for articling positions, I chose to article with the Crown instead of a defense firm, primarily because I thought I would get exposed to a broader range of work there and I might get, to take on more responsibility early on. But I do remember that during my articling interview, I was asked, where do you see yourself, 10 years from now?
Hmm.
And I said, I think probably doing defense work,
Oh, really?
because that's more philosophically aligned with my views.
Hmm.
And the person who was interviewing me said, you're going to change your mind. And I said, I don't think so. But of course, turns out she was completely right. I did change my mind. I did not really have a sense of what crown work was, I think, when I was in law school. And so, yeah, once I sort of discovered what it was, what it involved, it turns out it was a really great fit for me.
So you mentioned that one person. Were there any other specifically impactful cases that kind of encouraged you to step into the world of criminal law?
Yeah, I mean, I think, the parts of law school that really interested me, and in particular as it relates to criminal law, were these sort of this sense of this kind of feedback loop between the law and our sort of social values and structures, right? This idea of how, legal systems both impact and are impacted by, existing power structures and the
Hmm.
systems that we rely on. And so, in particular, I was interested in how, the laws and our legal processes reflect and entrench sexist and racist attitudes and ideals. And so there were two cases in particular that really kind of stand out to me. So the first is it's a case called R and Dudley and Stevens. It's a case from 1884 and it involves high seas cannibalism.
Oh, well, I
So
have never heard of that one.
Well, it doesn't come up, I think, ever except in law school.
Okay.
What happened was some sailors killed and ate a cabin boy to survive. And, it engaged the defense of necessity and it kind of, engages some of those questions that I was already really kind of struggling with. Who gets to make these decisions and sort of the trolley problem, right? Is it better to kill one person for the good of many or
Right.
do nothing but let many people die? And then, sort of that question of like, why was it the cabin boy that had to die,
Hmm.
so that everyone else could live? Who made that decision? So that case, I think was maybe one of the earliest ones that really stuck with me. The second case, I think, maybe hits a little closer to home, and it's the case of Jane Doe, who sued the Toronto Police for negligence and for violating her charter right to security of the person and her equality right under Section 15 of the Charter. And of course, Jane Doe was sexually assaulted after a man used her balcony to break into her apartment. I think this was in 1985 or 1986. And she wasn't the first person to have been sexually assaulted by this man. I think she was the fifth person to be sexually assaulted by this same person. He came to be known as the balcony rapist. And even though police knew that there was a serial predator targeting women in this particular neighborhood, they made a deliberate choice not to warn the public because they didn't want to tip him off. So they wanted to catch him. And so Jane Doe successfully sued the Toronto Police. I think her lawsuit was concluded in 1998. And she came and spoke to my law class when I was in first year,
Oh,
and that was
wow.
1999. So it was incredibly impactful. I remember her speaking about how she felt like she was used as bait by the police, how sort
Mhm.
of dehumanizing that was. Um, and I remember really being struck by this tension. I mean, the police are trying to catch a dangerous sexual predator who's targeting women. But the way they went about, sort of achieving that very, important goal exposed Jane Doe and others, to unacceptable risk.
Right.
So again, it kind of comes back to that question of like, who gets to make these decisions? Who are the people who are making these decisions? Jane Doe and these other women who were exposed to the risk of sexual violence, they had no say, in
Mhm.
the matter. They had no voice. And that sense of powerlessness has always really stuck with me.
Mhm.
And then the other part of that story that really stuck with me is the way that Jane Doe used the legal system, used a legal process to sort of reclaim some of her power and reclaim her voice that was taken from her. That was really powerful to me as a law student.
Well, that's amazing. And I know a lot of the work that you do now focuses on vulnerable victims, many of which are sexual violence cases. I believe you're now the chair of the Ministry of the Attorney General's Sexual Violence Advisory Group. Can you tell us a little bit more about what that group is?
Yeah, absolutely. So, the Sexual Violence Advisory Group was formed in 2015. It was part of then Premier Wynn's Sexual Violence and Harassment Action Plan. And it was sort of a multi-pronged approach that affected a number of different, aspects and ministries. And for the Ministry of the Attorney General, it created this Sexual Violence Advisory Group, which is a dedicated group of seven specialized prosecutors. And we were given the mandate of developing an enhanced prosecution model for sexual violence cases and trying to improve the victim's experience in the criminal justice system in particular. So, I think this was back in 2015. At the time, I wouldn't say that I had necessarily, specialized exclusively in sexual violence cases at that point. I'd certainly been, more attracted to cases with vulnerable victims and had done a lot of those cases. I was very much attracted to the sort of the complex, legal framework,
Mhm.
in sexual assault prosecutions, but also the sort of challenging human dynamics in those cases. And I debated when the position became available and when the sexual violence advisory group was created. On the one hand, it was like, wow, what an amazing opportunity. But I was also a little bit reluctant because doing this kind of work really does take a personal toll. And I
Right.
wasn't sure that I wanted to sort of do only, this kind of work. But ultimately, that sort of the opportunity to kind of build an enhanced prosecution model from scratch was too alluring,
Mm.
and I'm really glad I did sort of take that leap because it's been an absolutely amazing opportunity to sort of really develop a depth of knowledge in one particular area of criminal law, which is something as prosecutors we don't often get that opportunity to do. Most Crown prosecutors are sort of generalists. We do a little bit of
Mm.
everything.
I see. So was being part of this advisory group what led you to take on the Hockey Canada case?
Um, Not necessarily. So the Hockey Canada case was assigned to me, which is pretty much how every case, comes into the hands of any particular crown. But it's a little bit unusual because it was a case being prosecuted in London, Ontario, and I don't work primarily in London, Ontario.
Right.
But obviously, it was sort of anticipated that this was going to be a major prosecution that would take a lot of time, not just for the trial itself, but also in the lead up to the trial, right? So the case management aspects, when you have five accused, are going to be pretty demanding. So, I think it was always clear that there was going to need to be more than one crown on the case. Taking two crowns from the London, Crown's office would be a significant drain on the resources of that office. So I think it probably made sense to bring someone in from outside of London. And it was just a good fit for my experience and the position that I was in at the time. So I'd recently become the chair of the Sexual Violence Advisory Group. I didn't have a demanding trial schedule. My schedule was a bit more flexible, so I could handle the amount of case management that would be involved in this particular case. And I had done other cases that had attracted media attention before, so I had that kind of experience as well.
Yeah, I want to talk to you a bit more about that because you also mentioned the personal toll that these types of cases has on you. So when you got this case, how did you prepare yourself mentally and emotionally?
Yeah, that's a really good question. I think, one of the most important parts of preparing a mentally and emotionally for the case is sort of making sure you've got a solid support network in place, knowing, what the demands are going to be. So, a big part of that is, your sort of home, support and network. And, so knowing that you've got your sort of family and friends that you can rely on. But there was also sort of different aspects of developing and sort of making sure that my work support network was in place as well. So part of that involved getting to know who my co-counsel was, someone who I didn't know, before I was assigned to this case. And so we had to sort of develop a working relationship. We had to get to know each other and figure out how we can work together. And we did that from afar, before
Right.
the case began. Same with the investigating officer in the case. It's really important to sort of build trust and, sort of develop a rapport with the people that you're going to work with, knowing that once the trial actually gets going, things can get pretty intense. And so you need to have that kind of established, relationship before you get to that point. I would also say that, part of it for me was, recognizing early on that, once this trial began, it was going to demand my full attention.
Right.
So, I had to be kind of mentally prepared to let other things take a back seat. And for me personally, because I'm a bit of a control freak, I had to sort of know that I was leaving other things in good hands,
Mhm.
both on a personal level and a professional level. So, I had amazing colleagues on the Sexual Violence Advisory Group who stepped in to handle all of the other stuff that might have pulled my focus away,
Hmm.
during the trial. My husband was effectively solo parenting, during the trial. But I, was confident that all of that was, well in hand. So it was really about, sort of trying to get everything in place ahead of time before the trial began so that, I would be able to devote, my full attention to the trial once it was happening.
So once everything's set in place, I was wondering if you could take me through a day working on this case, preparation, talking with your co-counsel. How long are your work days and how do you schedule it?
So, yeah, during the trial itself, the days were long. I was living, in a rented apartment in London, Ontario, 650
Hmm.
kilometers away from where I normally live. So, my routine during that trial was not at all usual in terms of what my life would be like at home. So I would say, during the trial, I think typically I would wake up around 6:30 in the
Hmm.
morning, have some breakfast, do a little work. I was able to walk to the courthouse in London. I was near enough to do that, so I appreciated, that opportunity to get outside. And then, you get to the courthouse. I was, lucky enough to have an office, within the London Crown Attorney's office at the courthouse. So I had a place where I could sort of leave my things and print things as needed. I would connect with Heather, who was my co-counsel. Sometimes we would need to connect with witnesses or the investigating officer. We would be doing some last minute prep for arguments we knew were going to arise
Hmm.
that day or printing of exhibits and things like that. And that's all sort of before, we head up to the courtroom in London. The courthouse is very vertical. I think there are
Oh.
14 floors. Yeah. So our courtroom was on the 14th floor. You really can only get there by elevator.
Hmm.
And there were generally only sort of one or two of the three available elevators in operation. So you had to leave a little bit early to make sure you were going to get up to the courtroom in time. So court starts at 10
Hmm.
typically. So, around 9:30 or so, we'd start gathering our stuff and getting ready to kind of head up to the courtroom. And then the court day usually goes till about 4:30 or 5. After that, we do some more debriefing. I'd speak with my co-counsel, sometimes the investigating officer. Again, we're making, arrangements for witnesses the next day, doing all of that kind of stuff, talking about what issues might arise the next day, dividing up work, doing that kind of thing. And then, sort of getting home around, I don't know, between 6 and 7, have some dinner, sometimes do a little bit more work. I tried to leave, an hour or so before bed to
Mm.
sort of, decompress
Right.
from the day. I actually find for me, jigsaw puzzles are the way to like shut my brain
Oh, I'm
off.
with you. I love a good jigsaw puzzle. I know that the listeners can't see, but behind me I have a giant painting, but it's actually a jigsaw puzzle. Something
Oh,
that you do in a
amazing.
cafe at night. And I'm the type of crazy person that glues my puzzles and frames them. So there you go.
So I wish I could show you on my dining room table right now. I got a puzzle for Christmas and it's a 2,000 piece puzzle, but it
2000.
makes but it makes 8 planets. Like it makes each of the planets. It makes planet-shaped puzzles, but they're
Oh,
all
okay.
together in one 2,000 piece thing. So you have to first kind of sort them and decide. Anyway, it's a beautiful puzzle and I just finished it like
Well,
2 days ago.
congratulations.
Thank you.
Yes. So we talked about, all the prep work that has to go into going to a trial. And I feel like they don't really talk about the prep work, especially in like TV shows about criminal cases. When you watch a TV show, it always seems like trials are, an adrenaline rush. It's always like super dramatic. But what are some of the other big misconceptions that you think the public might have about criminal court?
Well, I think one of the big misconceptions is just how long,
Mm.
it takes for a case to make its way, through the criminal justice system. An episode of Law and Order, like the crime is committed and solved and the trial is over all within, a 1 hour episode. So I think it kind of sets up this idea that, these cases can move quite quickly when in fact they move slowly. And I think people also don't understand just how many steps there are in the process, right? So sometimes there are bail hearings, there could be a preliminary hearing, there are pretrial motions, there are all kinds of meetings between the Crown and the defense lawyer, judicial pretrials, which are meetings with the Crown, the defense lawyer, and the judge. And so things are happening on the case, but nothing necessarily, in court on the record,
Mm.
or even if things are happening in court on the record, it's not part of the trial. So I think people don't necessarily understand that there's a lot more, like the trial is kind of the tip of the iceberg, right? And the rest of the iceberg is all of the rest of the work that goes into getting ready for the trial.
How about any misconceptions about the role of a crown attorney?
Um, I think a lot of people don't necessarily understand what the Crown's role is. I think a lot of people think that the Crown is the victim's lawyer, right? They sort of view, a criminal trial as like the accused versus the victim. But that's not what a criminal trial is, right? The Crown represents the public, not the victim. And there's an aspect to the Crown role that is sort of a quasi minister of justice role. The Crown has to act in the public interest, and that includes a victim is a member of the public. It includes taking the victim's, views and interests into consideration. But, ultimately the Crown is acting in the public interest. And, I think people also don't necessarily understand just how much discretion individual crowns have,
Mm.
in relation to the cases that they have carriage of. We do have policies to follow, but for the most part, they're not rigid, and individual crowns do have a lot of discretion. And in fact, the system relies on individual crowns, making principled decisions in each case, making decisions about whether there's a reasonable prospect of conviction, making decisions about what is in the public interest and how to conduct their particular case. Part of that sort of responsibility, is what attracted me to the
Mhm.
Crown, role. It's a responsibility, but it's also a freedom because, it is the Crown's job to do the right thing.
And if I can get into the Hockey Canada case just in particular, in your opinion, since you worked firsthand on this trial, what were some of the biggest misconceptions that you think people might have had about this case?
Well, one of the issues that I saw come up a lot was some confusion about the decision to prosecute, and how that decision gets made and who makes that decision. And I don't think it's necessarily unique to the Hockey Canada case. I think in general, the public doesn't necessarily understand what goes into a decision about whether or not to proceed with a criminal case. And in Ontario, the decision about whether to lay a charge, right? Like if criminal charges are going to be laid and what charges are going to be laid and who's going to be charged, those decisions rest with the police. There can be consultation between Crown and police, but ultimately it's a police decision, whether charges are laid. But once the charges are laid, then it's the Crown's decision. Then it's up to the Crown to decide what's going to happen to
Mhm.
those charges. And, in making that determination, the Crown has to assess, is there a reasonable prospect of conviction? And is the prosecution in the public interest? And, public interest is another thing that I think, people don't really understand.
Mhm.
Public interest involves assessing a lot of different factors, but the public interest assessment is not influenced by politicians. It is not influenced by public sentiment, right? It's not about what the public wants.
Mhm.
It's about what is in the best interests of the public, right? And so, a prosecution can only proceed, a Crown can only proceed with a prosecution if they have concluded that there is both a reasonable prospect of conviction and a public interest in the prosecution. So a really strong public interest cannot make up for an absence of a reasonable prospect of conviction.
Right, right.
Right. And so, a reasonable prospect of conviction means that a guilty verdict wouldn't be unreasonable.
Mm.
That's the sort of the test. So, as I sort of said earlier, as a prosecutor, it's your responsibility to proceed with cases where there's a reasonable prospect of conviction and it's in the public interest. But it's also the prosecutor's duty to discontinue a prosecution if you don't believe there's a reasonable prospect of conviction and that continuing is not in the public interest.
We talked about the complexities that go into this case, but also how you need to decompress from the pressures of it all. Do you find it hard to detach from cases when you're working on them, especially cases of this nature? Is this even a goal or something you strive for, or do you like to be fully immersed in a case when you're working on it?
That's such a great question because I don't think that there's sort of a right or wrong answer or one answer that sort of works for everyone or even that works for me in all cases. It's very sort of individual. This kind of work does carry a very high risk of vicarious trauma and moral injury. And, part of, I talked earlier about this enhanced prosecution model, that we developed as part of the Sexual Violence Advisory Group. The enhanced prosecution model, really at its core, is a trauma-informed prosecution model. And part of, prosecuting sexual violence cases effectively requires understanding, the impacts of trauma on, the people involved in the case, but also how it can affect us as well. And one thing that we have learned is that, traumatic memories are very difficult for someone to sort of access and
Hmm.
communicate. But you give them the best chance of being able to access and communicate those memories effectively if you can sort of put people at ease, right? The more anxious and defensive, and uncomfortable someone is, the more difficult it's going to be for them to access and communicate those traumatic memories. So the reason I sort of think that's important is because, making a human connection, with the complainant in, any particular case is absolutely critical, not only to, that complainant's experience, engaging with the criminal justice system, but it's also crucial for, a successful prosecution. It's crucial to allow the complainant to effectively, communicate her experience. So, completely detaching, is really not an option if you want to do these cases effectively. But, and some people talk about, you need to be empathetic. The difficulty with empathy, right, is that it requires you to put yourself in someone else's shoes. And that can be really taxing emotionally, right?
Mm.
Because then you're sort of feeling what they're feeling. Some of the reading that I've done talks about how a better approach might be focusing more on compassion, right? To try and understand what someone is experiencing and then respond to that,
Hmm.
right? To sort of fundamentally respect, the dignity of the people you're interacting with, rather than trying to sort of feel what they're feeling. So, I mean, that's the theory. In practice, I think most of us just kind of feel our way through it. Some complainants I connect to more on a personal level than others. Some cases require more immersion, than other cases do. For the hockey case, I immersed myself, in that trial in a way that I probably wouldn't for most other cases. But
Mm.
a large part of that was the unique living situation I found myself in, right? Living separate from my other sort of life commitments and activities that were otherwise kind of on hold, was just a bit of a unique situation. I think, for most people in most cases, it is really critical to sort of find a way to strike that balance and draw that line between your work life and your home life.
Yeah,
And I think most people would probably say that's a work in progress,
yeah,
right up until the point when you retire.
yeah. Did reading the news at all affect the way that you were working, especially on a case like this?
Well, that's interesting. I mean, certainly, I got lots of advice before the trial started not to read the news.
Yeah.
It's kind of impossible, at a certain point. There's a real risk that it can be a distraction. I think when there's a jury trial, in particular, I do find it helpful to sort of read how the journalists who are sitting in the courtroom are perceiving things.
Oh, that's interesting.
Well, because it gives you a little bit of an insight into how the jury might be perceiving things, right? These are
Mm.
also people who are sort of hearing the evidence for the first time. So I think that when I'm doing a jury trial, I do, like to sort of keep an eye on, some of the reporting for that particular reason. But I stay far away from social media. Not just in this case, that's sort of a life rule generally, but I'm very conscious of the sort of the negativity bias that exists, right? Like one negative comment, takes on a much more significant role than, 50 positive comments. So,
Yeah,
that was a distraction that I did not need. And so I certainly stayed far away from that in this case.
that's good. Good for you. Yeah. I have trouble detaching from social media, but hey, it's 2026. That can be my new resolution.
Not too late.
Exactly. After the verdict, you stood in front of reporters, and there's a clip of you where you said, and I quote, "A successful prosecution is not measured solely by whether there are guilty verdicts in the end. The Crown's goal throughout this proceeding is to see a fair trial." What were you hoping to communicate to the public when you were making those remarks?
I think that part of the remarks really touched on two things. First is that sort of idea of the quasi minister of justice part of the Crown's role, right? The Crown is not looking for a conviction at any cost. We are looking to have a case judged fairly through a process that respects the rights of the accused and respects the rights of the victim. So a fair trial is always the end goal, for the Crown, not a conviction. So that's part of it. And I think I was also trying to communicate that the public interest can be furthered by the prosecution itself, not just by a particular
Mm,
outcome. So, keeping in mind, of course, that public interest is not a substitute for reasonable prospect of conviction, right? So I'm not sort of saying that, a public interest alone is enough. But I think it's important that we don't sort of fall into this trap of saying, well, there wasn't a conviction at the end, so obviously the prosecution wasn't in the public interest. I think, in this particular case, because of the media attention, because so many people were paying attention to what was happening in this case, it really sparked important conversations about what consent is, about how consent can and can't be communicated. Important conversations about how well our law is doing at understanding complex behavior. Important conversations about how victims of sexual violence are treated in the criminal justice system. So I think, these are really important conversations for all of us as a society, to be having. And so I think, that's part of this. When the case was over, I received a lot of messages from members of the public who I didn't know, more than 50, in fact. And a lot of these messages were from women who, shared with me their own experiences of sexual violence. They talked about how they were not able to speak up or fight for themselves. And they talked about how seeing EM sort of break the silence and seeing her have the courage to testify and going through that, how it was so meaningful for them. Someone said her courage is
mm.
contagious. I think that part of it sort of speaks to the public interest issues as well. I think there are public interest goals that can be achieved through a prosecution that don't depend on the actual outcome of the case.
Yeah, and you spoke about the dialogue that's been ongoing, regardless of what the verdict is. And I was wondering if you think that whether or not this dialogue has reached a point where people are discussing, what are other dispute resolution methods when it comes to sexual assault cases? The words restorative justice are thrown around here and there, but what's your take on it? Like, are there alternative ways to address these matters?
Well, that's a really interesting and timely question. There are lots of conversations being had about restorative justice right now, in particular, how it might be used, in relation to sexual assault cases. I think it's important to contextualize this a little bit. Research shows that approximately 5% of sexual assaults are reported to the police, right? I mean, it's one of the most underreported crimes. And the criminal code and our Supreme Court say over and over again that we as a society have an interest in encouraging the reporting of sexual offenses. But we also have a delay problem, right, in our court system. So there's a tension between wanting to increase reporting and our system's sort of capacity to handle, an increase in volume. And so, I think it's important to sort of recognize the very important role that the criminal justice system plays in society, right? The criminal justice system, helps us maintain public confidence in the rule of law. It promotes, public safety and security. And so generally speaking, the criminal justice system is where serious crimes should be dealt with, right? That's the system that we have for dealing with serious crime. And sexual assault is a serious crime. And it's taken a long time, to have, the public and the courts recognize just how harmful and serious non-consensual sexual touching can be. Especially when there are no overt threats or physical violence involved. So I think it's important to make sure we're not, embarking on a path that moves us backwards in terms of recognizing the seriousness of sexual violence.
Mm.
But at the same time, it's undeniable that the criminal justice system is not right for every victim or for every case, right? There are, for very good reasons, a criminal trial requires the Crown to prove the case beyond a reasonable doubt, which is a very high standard. In most cases, the accused's fair trial right means that he will have an opportunity to cross-examine the victim, and that can be a very, very difficult experience for a victim.
Mhm.
So, I think it's important to ensure that survivors of sexual violence are informed about their choices and what might flow from starting down a particular path. And I think we need to do what we can to sort of empower survivors to make a choice for themselves about what process they want to engage with. And I have I have quite a bit of experience using restorative justice processes, as a Crown. I'm a huge supporter of these processes, generally speaking. I've had a lot of very positive experiences with them.
Mhm.
But, I know some people have expressed concerns about, the specifics of how we can use these processes in the context of sexual violence. Should they be, should it exist as part of the criminal justice system or a complete alternative, to someone engaging with the criminal justice system? And I think, most advocates for the use of restorative justice in sexual violence cases, I think most would agree that, the process has to be victim focused and victim driven. It would not be appropriate for, a victim of a serious crime like sexual assault to feel pressured, into participating in a restorative justice process. And restorative justice also requires some sort of acknowledgement of harm done, by the offender, right? Or at least some kind of taking of responsibility or acceptance of facts, right? If you
Right.
don't have a sort of like common understanding or agreement about what happened, it's hard to imagine how that process could be, healing or restorative, for the victim. So, you know, I think it's a complex issue. I think these are, again, really important conversations to be having. I think we have to listen carefully when we're hearing, survivors of sexual violence, when we're hearing some of them say they want more choices, aside from just a criminal trial. It's important to listen to what they're saying. But I think it's also important not to view restorative justice as some sort of panacea or something that will be appropriate for all sexual violence cases, like it's a complete answer. I think it's complicated, and I think we're really just starting the important discussions about that.
Yeah, and that's powerful. And that's a great way to end things off. But before I let you go, I know that you're known for your focus on mentorship and championship of generations who are coming after you. So, what's a piece of advice that you would give to young Crown attorneys or anyone who might be interested in a role as a Crown prosecutor?
Two things. First, be yourself. This is a human job that requires you to bring all of your human skills, connection, communication, curiosity. All of this is critical. And young Crown starting out, will never be able to do the job exactly the same way that someone else does. I would tell, a young Crown to take inspiration from the people that you admire, but don't bottle up the things that make you you. That is the key to your success, as a litigator and as a Crown. And the second thing is be brave. Being a Crown means that you have the responsibility and the freedom to do what you believe is the right thing. Now, sometimes doing the right thing aligns with what others want, and sometimes it doesn't, right? So, as a Crown, it is really important to be guided by principle, not the desire to be popular. You can be a strong advocate in the courtroom and still fulfill that quasi-minister of justice role if you're brave. It is a great job. It won't feel like it some days, but it is tremendously rewarding if you stick with it.
Amazing. Well, Meaghan, thank you so much for your time. I think this is a great conversation, and listeners are going to have a great time listening to this and thinking about the topics that you've raised. So, Meaghan, thank you once again for joining us, and I wish you the best.
Thanks. It was my pleasure. Nice chatting with you.
Thank you for tapping into this episode of Law Syrup. Law Syrup is produced by me, Herman Wong, and the Ontario Justice Education Network. For more information and for accompanying resources, check out ogen.ca and our show notes. See you next time.